Linda Liukas to record it and put it on YouTube so that she could hear what I told yesterday. A previous dinner in 2001 in St. Louis during the International Conference of Artificial Intelligence and Law also had a dinner speaker. It was a local politician, but this local politician got stuck in a meeting and he couldn't attend in the end. We didn't care much then, but later, 5 years later, the organizer told us that this dinner speaker was Barrack Obama. So then we did care. This field of artificial intelligence and law I sort of left, and I now solely focus on internet law topics. But today actually is a day that uh, has a link with artificial intelligence law because I am one of the founders of the platform Open Commentaries, and today it is founded with a registration by the notary. And this platform Open Commentaries means to collect all kind of commentaries by lawyers that normally appear in journals on an open platform, a sort of Wikipedia initiative in the legal field. And I hope it will be successful. It will be a long way before it will become successful, but I hope it will become successful. The theme of this dinner speech is the future, and lawyers live in the past. So if I tell you about the future, I inform you about what happened next year, and particularly, I personally have a bad track record regarding telling the future. In '93, I was in Florence and there was a chestnut seller with a mobile phone. I thought, who would need a phone? Who would need a mobile phone? 5 years later, the internet was slowing down, and I told my colleagues, well, within 1 year or so, the internet will stop functioning. Again, 5 years later, someone was telling about people in Japan using small screens to access the internet. I said, well, who would need that? Who would use such small devices to access the internet? And a final example in 5 years later again, 2007, I thought that virtual worlds would be the future of disseminating information and disseminating knowledge. What I am good at is norms about the internet. I'm an internet lawyer, and we think about what should be done on the internet, the rights and duties, whereas politicians think about what's desirable and technology is about what's possible. We deal with what's permissible. And I will address some of the issues that are relevant in the field of internet law. Not only some of these, but the central issues for internet law and governance. The first and maybe the most important one is internet access. Finland was the first country in the world that had in its constitution the right of citizens to have access to the internet. The European Union wants every EU citizen to have broadband access within 1 year from now, in 2013. And the United Nations also wants to ensure universal access to be a priority for all states. So it's high on the political agenda to provide access. And access is in today's society an essential element of being a citizen. You cannot do without internet access. Everyone should have the right to access the internet. You cannot deprive people based on, for instance, three strikes legislation. You cannot deprive people access to the internet. It's too important for that. And there has been a recent verdict in the States where an American hacker was banned from the internet for 5 years. But it wasn't really banned from the internet because he is still allowed to the internet, but with permission. And well, that's a severe measure, but acceptable because he can still access the internet. Access, except for people in prison of course, but access to the internet is essential in our current society. Another issue is e-commerce. We are here with people from the e-commerce platform and the developments of smart devices. There are currently, I believe, 1 billion of smartphones, and within 4 years from now there will be like 5 billion. Almost the whole world population will have small devices, and that challenges the application of regulation that was drafted for the big screens. So in the big screen you can provide all kind of information. There are a lot of information duties, information requirements for information society service providers. But how can you communicate this information through a small screen? That's a challenge that we have to tackle within the next coming years in the field of e-commerce law. Privacy is of course a very important topic. My colleague from University of Massachusetts, Ethan Ketch, already 15 years ago wrote in one of his books, "On the internet, privacy is an illusion." And to a certain extent this is the case, but you should have control over your own personal information. And in my perspective, it's not good if companies and governments have too much control over your information, in particular not if you haven't asked them to do so. Like in case of Facebook, if I register as John Jones, then Facebook suggests me all kind of friends that could be my real friends, or people I really know. So apparently they have a sort of profile of me without I being connected in any way to them, and without giving my real name. They can still suggest my real friends, and that is sort of scary, that these profiles are built without your permission and without you even knowing it. Another topic somewhat related to privacy is security. I want to address it also shortly. What's important in security is that threats come from different actors, and depending on the actor, a different part of the government should react. Criminals, the police should react. If it's another state, then defense or external affairs should react. If it's terrorism, then internal affairs, etc., etc. What's important is that the already existing National Center for Cybersecurity will have a generic approach to the cybersecurity issues and deal with them in an integrated way, and not in all those pillars, not a defense pillar, an internal affairs pillar, a justice pillar. No, just a generic approach that all the threats of cybersecurity are tackled. And for lawyers, it's the challenge to define the legal competences for those for this collection of people working on cyber threats. It's very important to keep the internet functioning to deal with cybersecurity. Copyright is an issue that has been addressed at length also at this conference. And one thing that is important is that we should not consider the internet to be a printing press. We should reform copyright law. Nelly Kroes is doing that in the European Union. We should acknowledge on the one hand freedom of information and, what's important, the interests of artists. We should also acknowledge them and not take everything for free. That's not the good way to deal with copyright. But what's also wrong, what's currently happening is to stick too much to the existing framework and be very repressive. We should think about new ways, like Spotify is a splendid example of how you could distribute music over the internet, for instance. So we should forget, Jerry Barlow already told it almost 20 years ago, we should forget the old concepts and think about new concepts. Something related to copyright is the role of access providers, which is also a central topic within internet governance. What's important for access providers is that they become less norm enforcers. More and more they are asked to help in enforcing the law, and I think that they should basically restrict themselves to their traditional role of merely providing access. Sometimes they might be needed to assist, but their basic function should be um, providing access. And these days there are too many claims coming in the direction of the access provider. And the last topic, and not the least, is the freedom of speech, which is very important to me, that people can communicate freely on the internet. That's what the internet should stand for, and it's also within the United Nations it's recognized as a basic human right, the freedom of speech. But it's very difficult issue because of the cultural differences between countries within the European Union and between countries worldwide. And a nice example to illustrate it is the Hamza case, where someone in Saudi Arabia put on the internet tweets saying that he wouldn't shake the hand of Muhammad at his birthday, and the Muslims got mad, and he put the tweets after 1 or 2 hours, put them offline, but it wasn't fast enough because he was sentenced to death, or at least this was what people wanted. And what's interesting here is that there was a Facebook page, Death Penalty for Hamza, with 30,000 friends, and there was also a Facebook page about a worldwide freedom of speech. And that, the latter, is very important to strive for, that we will recognize all countries worldwide, that people should be free to say what they want. Of course they should respect right of others, but the basic right should be freedom of speech, and that's something we should work on the internet in particular, because everything you utter on the internet, of course, can be received worldwide. Then to wrap up, I am an internet lawyer. I am we are the internet lawyers are sort of spin in the web, the spin in the World Wide Web, and also the spin, the intermediary between, at the one hand, the lawyers, on the other hand, the technology people, because we know about the law and we know about the internet, and in combination we can bring what society is needing today. In terms of education, we're educating at university, for instance, more and more students. 2 years ago there were 15, and this year there are already 43 students. So there are more and more coming, and I think they are needed because the future needs us, and we are there. Thank you for your attention.